A very good morning to all my dear students. Today we are going to discuss about the procedure laid down under the Code of Civil Procedure, wherein we are going to discuss about the concept of summary suit as laid down under Order 37 of the Code of Civil Procedure. Further, I would like to discuss with you regarding the object behind summary suit. Further, I would also like to explain you the distinction between ordinary suit as well as summary suit. Thereafter, I would like to discuss with you the conditions for the granting of leave to defend and under what circumstances the leave to defend can be granted by a court of law to the defendant in a civil suit instituted by plaintiff. So, in this background, I just want also to recapitulate the concept of civil suit, wherein a regular suit or an ordinary suit for recovery can also be filed. As you all are aware, my dear students, that under section 26 of the Code of Civil Procedure, a plaint can be a mode for converting the same itself into a civil suit, meaning thereby every civil suit can be instituted only by way of presentation of plaint. So, my dear students, this also having again link with the concept of pleadings under Order 6 of Code of Civil Procedure, wherein, my dear students, pleading includes plaint or written statement. And I just want to recapitulate about the object behind the plaint. As you all are aware that plaint gives the necessary cause of action in favor of the plaintiff and thereby to claim certain reliefs herein. And thereafter, once this plaint has been admitted as a civil suit, my dear students, the court may thereafter issue summons to the other side. Here, I would like to explain also to you the concept of summons. My dear students, you all are aware that summons is a document on the basis of which, or in other words, the court may call upon the defendant to present himself before a court of law. thereby to give him an opportunity to defend his case against the plaintiff. Further, the time limit for presenting a written statement or the reply is 30 days from the date of the institution of civil suit. Furthermore, this time limit can also be further extended by a period of, or in other words, this period can be extended up to a period of 90 days. And thereafter, in an ordinary suit, the defendant has an statutory right or an inherent right to file its reply. But my dear students, this is not so in the case of summary suit, wherein before filing or before or in a summary suit, the defendant has no inherent right to file its reply as a matter of right. Furthermore, he has to take the requisite permission for filing the written statement in a civil suit as instituted by the plaintiff. Thereby, we may say that he has to take or he has to apply for leave to defend, whereby the court, on being satisfaction, or in other words, on being satisfied, the court may allow him to file its written statement. This leave to defend can be conditional or unconditional, but this would be dependent upon the facts and circumstances of each case. Now, my dear students, I just want to start with the set topic. Hope you will learn from the same. Now, as I had already apprised you, my dear students, that the summary procedure regarding a civil suit has been given under Order 37 of the CPC. Now, I just want to provide you the object behind instituting this suit. The object behind the institution of the civil suit under Order 37 is to expeditiously dispose of the case. And what type of cases can be filed, or what is the nature of the summary suit? It is only for recovery of money, wherein the commercial transactions are involved. And it also deals with the contractual issues. For example, like in the case of a contract between the two parties, wherein one party gives or writes a guarantee in favor of another party, then in those cases, leave to defend can be summary suit can be instituted. Furthermore, where there is a bouncing of check, or where there is an written instrument, this written instrument includes the check issued by the party in favor of another party. So from this we can draw an analogy that a civil suit can be instituted for dishonor of the check as well, apart from the other statutory remedies provided under Section 138 of Negotiable Instrument Act. So, my dear students, from this you may infer that there is an interplay between the Negotiable Instrument Act as well as the Code of Civil Procedure, meaning thereby this is an interconnection or an interrelationship between Code of Civil Procedure and Negotiable Instrument Act. Now I will move further, my dear students. As I had already apprised you that under summary suit, defendant is not having a statutory right to defend himself. So he has to take the prior permission of the court, either in writing or by orally. And this permission is known as leave to defend. Next, in which courts the summary suit procedure can be adopted, or wherein, or in other words, wherein these type of suits can be filed as per Order 37 CPC, my dear students. This would be applicable on high courts, civil courts, court of small causes, and other courts as specified by the High Court. And it is also based upon the negotiable instrument, or where the plaintiff seeks to recover a liquidated amount. So, my dear students, you may file as a law student or as a lawyer. One must keep in mind that liquidated sum of money must be involved in filing a civil suit, and meaning thereby unliquidated sum of money has not been included within the meaning of Order 37 Rule 1 CPC. Next, how the court will satisfy, or what are the ingredients of leave to defend? If the defendant, my dear students, if the defendant satisfies the court that he has a substantial defense, and that is the defense that is likely to succeed, the plaintiff is not entitled to leave to sign judgment, and the defendant is entitled to unconditional leave to defend. So to get an opportunity to get the rebuttal in filing this reply to the suit filed by the plaintiff, he has to satisfy the court that there is a substantial defense available with the defendant. If he is able to prove the same in the court of law, then, my dear students, that is the ground for grant of unconditional leave to defend. Furthermore, if the defendant raises any tribal issues indicating that he has a fair or reasonable defense, although not a positively good defense, the plaintiff is not entitled to sign a judgment, and the defendant is ordinarily entitled to unconditional leave to defend. So from this, my dear students, we may infer that leave to defend can be granted on the basis of fair or reasonable defense available with the defendant. If the same is available, then it is a good ground for getting an unconditional leave to defend that may be taken by the defendant or by his counsel. Next, even if the defendant raises tribal issues, if a doubt is left with the trial judge about defendant's good faith or the genuineness of the tribal issues, the trial judge may impose condition. So this is known as conditional leave to defend. In my previous two examples, I had discussed with you the unconditional leave to defend, where the court may give an unconditional leave to defend. Now I am discussing the circumstances under which a conditional leave to defend can also be granted. Even though there is a tribal issue, but the court is not satisfied in good faith, then in those circumstances, the court may grant the conditional leave to defend so as to expeditiously dispose of the commercial cases, and care must also be taken that such tribal issues are not set by unduly severe orders as to deposit or security. So in these conditional types of leave to defend, the court may allow the defendant to deposit a security amount in cases of a money suit. and thereby to give him an opportunity to give an to file its leave to file its written statement in a case. Next, what are the advantages of summary suit, my dear students? The summary suit gives an expeditious disposal of the case. Summary procedure prevents unreasonable obstruction by the defendant who has no defense. So, meaning thereby, if the defendant has no defense to defend his suit, then also this may be treated as an advantage because it will tantamount to expeditiously dispose of the case. So these are certain advantages of summary suit. Now I would like to give you or brief about the disadvantages of summary procedure. The summary procedure is generally resorted to in a class of cases where speedy decisions are desirable in the interest of commercial transaction. So its applicability is very limited in nature because it only deals with the commercial matter. It does not apply to the general matters as well. Next, summary suits are instrument of speedy remedy, and justice hurried is justice buried. So, my dear students, as the court may hurriedly decide the case, it may bury the justice also. So, these are certain disadvantages of summary procedure. So, this is all about, my dear students, about today's lecture. In case of any doubt, you may revert back to me by writing an email to me on my email ID, that is rahularora.gn@jagannath.org. Before parting with the today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture, and my next lecture would be on suit against indigent persons. Hope you have a great day ahead. Stay home, stay safe, be positive. Thank you very much. We'll meet you soon in my next lecture.